The National Environmental Policy Act, NEPA, was enacted in 1969, one of many legislative and executive responses to growing concern about the condition of the environment and about what human actions were doing to it. NEPA does two major things. First, it establishes a national policy regarding the environment. It's important to understand this policy to correctly interpret NEPA and its implementation. Second, NEPA requires that agencies prepare a detailed statement of the environmental impacts of any major federal action significantly affecting the quality of the human environment. This detailed statement is known as an EIS, an Environmental Impact Statement. NEPA has been amended several times since its enactment, the last time being in 1986, and a number of other laws have established interlocking or overlapping requirements that must be addressed in NEPA analyses. This procedural requirement and those that logically need to be followed in order to figure out whether an EIS is needed are complied with and following regulations issued by the Council on Environmental Quality, CEQ. Where did NEPA come from? The origins of NEPA are similar to those of the National Historic Preservation Act, NEPA, which was enacted 3 years before NEPA. During the 1930s, rapid industrialization created environmental problems, which were exacerbated by World War II. After the war, programs like urban renewal, the Interstate Highway Program, and the charge given to the Corps of Engineers to dam rivers for a variety of purposes accelerated this damage, as did the increasing use of toxic pesticides and fertilizers. Rachel Carson's pivotal book, Silent Spring, helped mobilize people to demand protection of the environment in a variety of ways, including a demand for more oversight of federal government actions. One major result was NEPA, enacted in 1969, but which was not implemented until the following year, 1970. The role of a federal agency in the NEPA process depends on the agency's expertise and relationship to the proposed action. The agency carrying out the federal action is responsible for complying with the requirements of NEPA. Lead agency. In some cases, there may be more than one federal agency involved in an undertaking. In this situation, a lead agency is designated to supervise preparation of the environmental analysis. Federal agencies, together with state, tribal, or local agencies, may act as joint lead agencies. Cooperating agency. A federal, state, tribal, or local agency having special expertise with respect to an environmental issue or jurisdiction by law may be required to be a cooperating agency in the NEPA process. A cooperating agency has the responsibility to assist the lead agency by participating in the NEPA process at the earliest possible time, by participating in the scoping process, in developing information and preparing environmental analyses, including portions of the environmental impact concerning that which the cooperating agency has special expertise, and in making available staff support at the lead agency's request to enhance the lead agency's interdisciplinary capabilities. Council of Environmental Quality, CEQ. Under Section 1504 of CEQ's NEPA regulations, federal agencies may refer to the CEQ on interagency disagreements concerning proposed federal actions that might cause unsatisfactory environmental effects. CEQ's role, when it accepts a referral, is generally to develop findings and recommendations consistent with the policy goals of Section 101 of NEPA. The Environmental Protection Agency, like other federal agencies, prepares and reviews NEPA documents. However, EPA has a unique responsibility in the NEPA review process. Under Section 309 of the Clean Air Act, NEPA is required to review and publicly comment on the environmental impacts of major federal actions, including actions which are now the subject of EISs. If EPA determines that the action is environmentally unsatisfactory, it is required by Section 309 to refer the matter to CEQ. In accordance with the Memorandum of Agreement between EPA and the CEQ, EPA carries out the operational duties associated with the administrative aspects of the EIS filing process. The Office of Federal Activities in EPA has been designated the official recipient in EPA of all EISs prepared by federal agencies. The public's role. The public has an important role in the NEPA process, particularly during scoping, in providing input on what issues should be addressed in an EIS, and in commenting on the findings in an agency's NEPA documents. The public can participate in the NEPA process by attending NEPA-related hearings or public meetings and by submitting comments directly to the lead agency. The lead agency must take into consideration all comments received from the public and other parties on NEPA documents during the comment period.